Alright guys, I'm going to talk to you briefly about an interesting Second Amendment case. And the case itself is very interesting, but what's even more cool is the judge that was involved. Now, I don't know if you guys remember Judge Amy Barrett. She was appointed and confirmed by Trump as a federal judge in 2017. She's also on his short list of Supreme Court justice nominees. In fact, her name was getting floated around kind of equally to Justice Kavanaugh when he was nominated. So I'd say she's rather high on the list. And I'll tell you guys real quick about this case. And, you can have your own opinion on the case itself. But even if you don't quite agree with the case, I think you're going to agree that she's going to be an awesome Supreme Court justice for the Second Amendment. And we really, really need to hope here that Trump gets another justice nomination. And hopefully for the Second Amendment, it's going to be Amy Barrett. So real quick about this case. And this case was decided on Friday, by the way, in the 7th Circuit. And there was a guy named Ricky Cantor, and he pled guilty to 1 count of federal mail fraud for falsely representing that his company's therapeutic shoe inserts were Medicare approved and for billing Medicare on that basis. Well, that wasn't true, and he misrepresented that fact. So he became a felon. And both federal law and Wisconsin law bar convicted felons from possessing a firearm. Well, on Friday, the 7th Circuit panel did rule that the application of those federal and Wisconsin laws to Cantor did not violate his Second Amendment rights. So nothing changed with the court case. However, Judge Amy Barrett, that I was talking about earlier, she was in the dissent. And I'm going to quote you, read a couple excerpts from her dissent. And I think it's pretty interesting what she had to say. She said, "History is consistent with common sense. It demonstrates that legislatures have the power to prohibit dangerous people from possessing guns. But that power extends only to people who are dangerous. Founding-era legislatures did not strip felons of the right to bear arms simply because of their status as felons. Nor have the parties introduced any evidence that founding-era legislatures imposed virtue-based restrictions on the right. Such restrictions applied to civic rights like voting and jury service, not to individual rights like the right to possess a gun. In 1791, and for well more than a century afterward, legislatures disqualified categories of people from the right to bear arms only when they judged that doing so was necessary to protect the public safety." She goes on further. "The federal and Wisconsin laws would stand on solid footing if their categorical bans were tailored to serve the government's undeniably compelling interest in protecting the public from gun violence. But their disposition of all felons, both violent and nonviolent, is unconstitutional as applied to Cantor. Neither Wisconsin nor the United States has introduced data sufficient to show that disarming all nonviolent felons substantially advances its interest in keeping the public safe. Nor have they otherwise demonstrated that Cantor himself shows a proclivity for violence. Absent evidence that he either belongs to a dangerous category or bears individual markers of risk, permanently disqualifying Cantor from possessing a gun violates the Second Amendment." So it's actually a pretty big dissent there. She's basically saying, look, if the government can show a compelling interest, they're going to protect people from danger due to somebody owning a gun. That's fine. And I think most of us would agree that murderers, rapists, the real bad guys out there, probably shouldn't own a gun. Most of us would agree with that. She went on further, though, to basically say, look, this guy's felony has nothing to do with whether he's safe or not. And she also cites laws of the first 100 years of this country that never actually barred nonviolent felons from owning guns. And our founding documents and our founding laws, the intent of the founding, fathers was never actually to bar felons. It was to bar people who would pose a danger and an imminent threat to the people and to society. So, and you guys might have your own opinions. Opinions are going to vary on whether felons should have guns or not. But I agree with her on what she said. A nonviolent felon, that there's nothing in their crime that would, lead people to believe they're a risk to safety, and there's nothing on any of their analysis that said this guy was dangerous. And I don't even think the state of Wisconsin or the federal government ever even tried to argue the guy was dangerous. They were just going by the laws that state that a felon can't own a gun no matter what. So anyways, regardless if you agree with her or not, I don't think there's any way you can disagree that she would be an excellent Supreme Court justice. So let's just hope that Trump can get his other pick in here, and hopefully he nominates Judge Amy Barrett. And I think we'd have a real winner for the Second Amendment on the High Court. All right, guys. Thanks for watching, and have a good one.